treatment under law, Article 25, and the right to education, Article 25A. It is a corollary of the person's right to dignity enshrined in the Constitution that his or her language, national or provincial, should be respected and recognized by the state which exercises authority over him or her. Likewise, it is a corollary of a person's right to equality that he or she must not be denied access to economic and political opportunities because he or she is only conversant in the languages recognized and referred to in Article 251 and not conversant with the English language. In the human rights case 17599 of 18, reported in the year 2019, the court took suo motu cognizance of the alarming population growth in the country and noted its adverse effects on the social and economic development of the nation. It observed that fundamental rights such as the right of free speech or information are of no use to those struggling with malnutrition, hunger and starvation. Economic prosperity is thus a sine qua non for the implementation of all fundamental rights, the paramount right being that of life. The task force constituted on the direction of the court made several recommendations for managing the population boom. However, we are disappointed that progress on that matter has stalled. The court proposes to revisit these proceedings to focus the energies of the state and the society on this crucial priority. Now, ladies and gentlemen, as the concept of rule of law has matured over the years, so have the essential features that comprise it. Therefore, good governance, which is generally understood to be synonymous with sound executive management of state functions, is now also regarded as one such feature of the rule of law. Good governance has great importance in safeguarding people's economic fundamental rights. This is evident from the court's pronouncements in Mohammed Yasin's case in the year 2012. It has been observed correctly by the court in Tariq Azizuddin's case in 2010 that good governance in the country is largely dependent upon an upright, honest and strong bureaucracy. The jurisprudence of the court has therefore developed in two directions. Firstly, by promoting merit and competition in the appointments made to the service of Pakistan, and secondly, as an offshoot of the first category, by protecting the public assets of the state from waste and plunder. In respect of the case law emanating under the former category, the court has consistently held since 1993 that appointments to public offices must be made on the principles of transparency and publicity and competition. An analysis of the court's case law is recently carried out in the Hidayatullah case in 2022, wherein the Sacked Employees Reinstatement Act 2010 was declared ultra vires the Constitution for allowing reinstatements of employees to the service of Pakistan, contrary to settled principles of due process for establishing merit, non-discrimination, transparency and fairness. The court took this strict view to ensure that people are served only by duly qualified and meritorious public officers. However, keeping in view the length of service rendered by the employees, an opportunity was granted to those employees who fulfilled the prescribed conditions of eligibility and qualification in order to be reinstated. Unfortunately, the court's efforts in the cases of mismanaged state assets was less productive. For lack of judicial expertise in this area, as well as lack of legal content in this field, having learned from experience, the court now exercises judicial restraint in matters involving economic decisions. Unless there is violation of the relevant regulatory law that leads to waste of public assets, causing a loss to the public exchequer and consequently the people. In this regard, one reference can be made. The court took notice in suo motu action regarding maintenance of foreign currency accounts in the year 2018 and made the government aware of the lacunas in the laws which allowed unregulated outflow of foreign exchange from bank accounts in Pakistan, thereby encouraging the government to make appropriate amendments to the amendments. These were indeed introduced by the government in the Income Tax Ordinance of 2001 in the tax year 2018. Ladies and gentlemen, by taking all of you on this journey to visit some of the landmark judgments delivered by the court, I have attempted to give a brief but overarching view of the court's prior efforts to uphold different aspects of the rule of law in the country. However, it is a shared belief in the judicial community that if we are to truly progress as a nation, which is fully committed to the ideals and aspirations of the Constitution and the rule of law, then all stakeholders in the justice sector need to rise to the challenge. The judiciary cannot pursue these ideals single-handedly. The other organs of the state, namely the legislature and the executive, must also adhere to constitutional principles and ensure that their actions advance rather than negate the ideals and aspirations of the Constitution. Additionally, the executive must also be diligent in implementing decisions of the court, especially in matters of constitutional importance, without undue delay, to truly anchor the rule of law in the country. The court has the power to declare the rights guaranteed to the people by the Constitution and the law, but it cannot implement the same except in very limited circumstances. Therefore, it is the executive which must take charge in this field and ensure that the words of the court are translated into practical action for the people. The bar is also expected to join hands in delivering justice where it is most lacking by making the courts or other fora of dispute resolution accessible to people who cannot access these due to reasons of poverty, marginalization, and illiteracy. The culture of filing frivolous cases must also be curtailed so that genuine grievances of the people are addressed. Where the filing of such cases is observed, cost should be imposed on litigants to ensure an efficient and effective functioning of the court system. On our part, concerted efforts are underway to reduce the backlog of cases to ensure that justice is delivered inexpensively and expeditiously to litigants. Briefly, some of these measures are as follows. Encouraging litigants to make use of alternate dispute resolution mechanisms to amicably resolve their legal disputes. 2. Frequently hearing cases through video link, digitalization of the judiciary, thereby reducing the cost incurred by the litigants as well as their counsel. Prioritizing early release of cause lists. Giving priority to hearing regular matters. Fixing special matters after normal court hours. Maintaining the continuity of benches so that part-heard cases may be decided. And, of course, finally, to have a brilliant case management committee comprising illustrious judges like Justice Mansoor Ali Shah and Justice Munib Akhtar, with whose efforts this court has, for the first time in 10 years, ever since our computerization of caseload was started, first time we have managed to reverse the trend of increasing backlog. Inshallah, we expect that once the shortage of judges in our court, which is almost 1/3 of its strength, will further improve our performance. Our target 6 months ago was to come below 50,000 cases at the start of this judicial year. Unfortunately, we've missed the target by 173 cases. Which is all right. The larger issue of backlog lies not at the court's doorstep, but the district level, where around 1.7 million of the approximately 2.1 million cases pending in the country are awaiting adjudication. Under Article 203 of the Constitution, it is the duty of each High Court to supervise and control all courts subordinate to it. Therefore, they are expected in the liaison with the National Judicial Policy-Making Committee to devise strategies to equip the district judiciary with the necessary tools to ensure swift and substantive justice to the people. To achieve the objective of dispensing substantive justice, the court is fully aware that the task of tweaking the law purposively lies with it, because the district courts and the high courts are bound by the Supreme Court precedents. At present, our criminal legal system has a low conviction rate due to poor investigations and a heightened focus on procedural technicalities. Therefore, to bring a balance between the rights of the accused and of the victim, it is the court's duty to re-examine the principles of criminal law and recommend changes where necessary to ensure a society free of crime and disorder. Similar efforts to the people. To achieve the objective of dispensing substantive justice, the court is fully aware that the task of tweaking the law purposively lies with it, because the district